303.49. My lord, may I submit, my lord? This is a rank jumping case, and the similarly situated people are already working, and I'm out of job. My only respectful submission is still, my lords, dispose of these matters. I may be permitted to work, my lord. My lord,
No, I didn't understand.
my lord.
No, nothing can be done.
My lord, my lord, another.
This is our time to be not real argument.
Yes, you have to start now.
Yes.
30351,
Second
Lord,
point.
I have a submission. There is one lady, Anamika, who was appointed by virtue of an High Court order, and she, another lady was thrown out of that. She holds highest merit in the category, and she is being appointed, my lord, that should not be.
No, we are going by what has been argued. We cannot go into individual cases of that nature. If we accept your plea that individual cases can be gone into, then we'll go into that. We can't otherwise.
Lord, in
Lord,
303.5, Lord, in 303.5, I want to make two submissions, Lord. Brief submissions, Lord.
We have already heard all of you. We are not going to
Lord,
comment that.
two brief submission, Lord. I am representing non-tenanted people who left the job and joined this service, Lord. That was one. And second, Lord, what is deliberated as if the OMR itself is not authentic, Lord. OMR is authentic. What was manipulated was the mark tabulated in the Excel sheet.
We have already argued, please. That's been
Lord,
already.
my IAs may be taken note, Lord.
No, we are not going into individual cases. Whatever has been argued, if they noted.
No, there is only one thing I need to point out. My lord, in a case where the single judge, my lord, directed finding jumping in my application, my case to be considered, having been considered appointed, division bench confirms that has attained finality. There is no reason why, my lord, that appeal can be reopened as a result of
by the division bench pursuant to order of this court. Therefore, nothing will individual cases to be considered.
Please start.
My lord, I appear in 303.8. I only want to make one point in 30 seconds, my lord. Just 1 point in 30 seconds, my lord.
Yes, please.
My lord, if your lordship would see paragraph 240 of the impugned judgment, the honorable court has gone by the percentage of tainted candidates vis-a-vis those appointed. But your lordship will see from the written submissions of the CBI, the number of investigated candidates were the entire percentage that was that participated in this election. So to that extent, saying that 8.5% of teaching community and 14.47% of the teaching community teaching candidates were tainted may not be a fair representation, because the actual taint has to be seen vis-a-vis the number of candidates who participated. And that your lordship will see comes to less than 2% in both cases, my lord. That is point number one that I wanted to place.
They haven't gone into those figures.
Yes,
they
but
cannot go into those figures.
But
they only went into the figures with regard to those who had been appointed.
Yes, but that is what I wanted to say is that may not be
an
accurate.
It's not possible.
But that may not be an accurate impression, because CBI investigated everybody.
Okay.
The ultimate percentage is only 2% of the total who participated. That is what I'm saying, my lord.
Where do you find that?
My lord, the fact that they investigated everybody. The fact that they investigated everybody, my lord, your lordship will get that from CBI's.
How many people participated?
My lord, the exact number is not on record, my lord. That exercise nobody has done, my lord. That is what I'm saying. 25. My lord, because otherwise para 240 appears to give an impression that nearly 10% of the candidates who are appointed are tainted. But really the percentage has to be calculated vis-a-vis the whole people who participated. The fact that CBI investigated others also is coming from CBI's written submission, my lord.
Okay.
Much grateful, my lord.
Second point of the state, your lordship said deferred. Your lordship will hear it later on, my lord.
Second point.
Lord, that's regarding, Lord, the direction number 8 at page 281 regarding the government order for supernumerary post which had been created. So there was a direction for a CBI inquiry. So
that part we'll hear you little later. That part we can hear.
Lord, there is item 303.52, my lord. It's a batch matter, my lord. Saddam Hussein's matter. And we were appointed regularly by untainted people, my lord. And
we have heard arguments extensively for 2 days from your side.
Grateful, my lord.
303.86, my lord, it's a matter where I was put in the list, tainted list, because my B.Ed degree came later. Otherwise, I completed all the. My lord, I have written
The
submission.
entire selection was vitiated because of malpractice sponsored by the state government. I just point out to your lordship, kindly turn to page 1167 of volume 5B. This was an application made by the School Service Commission before the Honorable High Court, seeking protection of appointments of all illegal appointees.
No, you are paying for whom?
I am appealing for the original petitioners who are asking whether that the entire selection is bad, should be set aside. And that was the order of the division bench.
Yes, please.
Now, the Miley
Which file are you taking as the lead file? 303?
Volume 5B. Volume 5B. Volume 5B.
June bolo, সবাই বললে হবে নাকি?
Volume 5B. Not been given in the template.
Whether I am referring to volume 5B, the compilation which
5 and 5A, 6 and 6.
Document 5B, something like that.
is there.
Volume 5B. Miscellaneous volume 5. Top one.
Pen drive was made by the office or by the?
5B is there.
1171.
Last one.
Five is not there.
Miscellaneous. No.
Volume 5B.
V followed by I is 6.
Page 116.
If you're going to show it on this, then don't waste time. 5B.
Page 1167.
So that's 6B, not 5B.
B.
And
5B seems to have been added later. 5B is not there. You have at the top miscellaneous 5B. That's not there in the pen. First one is miscellaneous 5B. No. Well, actually, the B and B are connected to each other.
So, 5B is there in the top.
So 5B.
5B is there.
Yes.
I believe bylaws have got it. Now, the state government in a very peculiar manner created certain new posts under the garb of supernumerary post.
No, don't come to that first. First, you deal with the other main contention. That's the second part. First, deal with the main contention. Is there justification in cancelling the entire
Yes,
result?
I'm not. On that, I'm showing lordship.
Please concentrate on that
Yes, no,
before you go to the second point.
No, but I will show this to show that this is really vitiated the entire process. That's why the separation is not possible, because the state government wanted to protect the job of the illegal appointees. Therefore, state government's machination was to ensure that illegal appointments should stay. Now, to support that, I just kindly take the trouble to paragraph 6 at 1171. This is the statement by the School Service Commission before the High Court. It is proposed, it is humbly proposed that apart from giving recommendations and appointment to the genuine candidates, as observed by this Honorable Court in other similar matters, supernumerary posts be also created to accommodate those, if any, whose appointments have been found illegal. Such proposal will result in no loss of jobs or to enable such appointees to have means of livelihood. However, in the event of such proposal being accepted, appropriate directions be given.
This is what? This is a reply? No.
This is an application filed by School Service Commission seeking permission for numerary category only need to protect the illegal appointees, number one. Number two, when the matter was going on before the division bench gave 4 chances to the School Service Commission to file affidavit. I will show the affidavits. So for the keeping of mirror copies, there is by the School Service Commission before the Supreme Court that the decision was taken. Decision was taken to destroy the original OMRs, keeping the mirror copies. And now ultimately they say we did not keep mirror copies, giving a
Go one by one. We have understood your first argument that they wanted to even uphold appointment of illegal appointees by creating supernumerary posts. That point we have understood.
yes. Second
For
point,
your cases, they wanted to favor the illegal appointments, and therefore their stand should not be accepted. That is possible to segregate illegal from genuine appointment.
in support ask the SSC that you give me the exact number who, according to you, are legally appointed. The SSC got 4 chances, they filed 4 affidavits. I will just refer to your lordship 2 affidavits where SSC says we are not sure. Kindly turn to at page 3154.
Which volume is that?
Same volume 5B. This is the latest affidavit by School Service Commission before the Honorable Division Bench. Classified like this, numbered, identified so far. There is no definite number, and this is the situation in all the 4 categories, 9, 10, 11, 12, Group C, Group D. In all cases, they are saying that this is not exhaustive, they cannot.
Not included.
And in this chart also, my lord will be pleased to note that the appointments given out of panel, persons who did not appear, they have been given appointment. Those data are not there. That's why he was directed to refund the money. On the last occasion, he appeared seeking my lord's kind leave to get the money back. How many of such cases are there? The School Service Commission could not yet identify. Therefore, this segregation is not possible. That is clearly discussed by the Honorable Division Bench. I will just refer to the 11th paragraph of the agreement. Now kindly turn to again the 4th affidavit of SSC, page 3249. Kindly turn to my paragraph 5. May I read for my lord's consideration? With regard to the issue of rank jumping for class 9, 10, it was stated in the report in the form of an affidavit that out of the 183 candidates, 122 candidates have been removed and 16 were still remaining. However, it is pertinent to further mention that out of the 61 remaining candidates, 40 candidates were neither in the panel nor in the waiting list. That is, they had not participated in the personality test. It may also
What
be
is
noted.
this remaining 61?
Hello?
The remaining 61 is what?
Who did not even participate.
So 61. Okay, if you remove.
Then next.
Out of 183 candidates,
122 remains. 122 they have removed pursuant to direction of the court. 61 they did not, and they did not participate in the selection procedure. Paragraph 6. With regard to the issue of rank jumping for class 11 and 12, it was stated in the report in the form of an affidavit that in cases of 39 candidates, no action has been taken and all 39 are still remaining. However, it is pertinent to further mention that out of the 39 remaining candidates, 18 candidates were neither in the panel nor in the waiting list. The persons were appointed who did not participate. That number is also not definite. Only these numbers, when you pointed out to that, they this affidavit.
$39 is a figure. How do we arrive at $39 figure?
Look, we had pointed out that we come to these people have been appointed. Then only they say. They don't have their own. Therefore, the court directed you on your own find out. SSC did not find on its own. Paragraph 7 is with regard to the OMR sheet. That was interesting. With regard to the OMR sheets for class 11, 12, it was stated in the report in the form of an affidavit affirmed on such and such that out of 9 7 candidates having OMR issue, 7 were recommended. In addition to that, said 771, there was one more candidate which the commission inadvertently did not mention in the said report in the form of an affidavit, namely one Rudra Prasad, who was recommended pursuant to direction dated such and such. Subsequently, it transpired that the said Rudra Prasad was one of the 907 candidates for class 11. Marks is mismatch, and his name appears in 907 candidates. At serial number 854, his marks as per evaluation of scan image of AMR is 23, while his marks in the server of the commission are 53. That's why the division bench repeatedly asked them and file affidavit. They could not file, giving a particular number. Then paragraph 8 is more important. It may be noted that pursuant to the order dated 2nd December, passed in WPN so and so. The commission issued letters to the concerned district inspector of schools for stopping the salary of group C so and so. Subsequently, by an order dated 15th February, the Honorable Court was pleased to direct the concerned district inspector of schools not to pay any salary to the concerned candidates any further. By a similar order, the commission was directed to issue letters to the concerned district inspector of schools for stopping the salary of group D candidates who were appointed after the expiry of the panel, and by a subsequent order directing concerned DI has been stated with regard to the candidates called by the 8th phase all candidates were called strictly on the basis of merit, though after expiry of the panel, how could the people be called for counseling after expiry of the panel? At the same date place counseling carried on 3rd of August 2020, 184 candidates were called out, of which 127 were present. It may be noted that the panel had expired on 19 December 2019. Two more candidates, one Salma Sultana and one Ritika, was also recommended. Therefore, these are the instances galore, which shows how there has been a and that's why the Honorable Division Bench kindly consider
Supreme Court and I can't scan email.
and we have to keep these scanned images. They did not. Kindly turn to the affidavit by the SSC before the Supreme Court at page 2901. Well, at para 2901, para Roman 7, at page 2901, sorry. It is stated that the chairman of the commission in executive capacity, after the expiry of 1 year in absence of rules, issued executive instruction directing that the answer script Weimar and other papers related to the disposed and destroyed at the period of preservation of the same had already expired. The same was to be destroyed after scanning in digital form. On the first day, the Honorable Court asked them, why did you not keep the mirror image? That was their own decision, they violated. Ensure that ultimately nobody can identify how many persons have been appointed. In spite of such, when some RTI applications were made in 2024, they have supplied the copy of at page 1257. These are the nature of illegalities they have committed. This is a letter from Assistant Secretary at page 1257 dated 18th of January 2024 with reference to your RTI Act as per data stored in commission's data. Now when the judgment could be brought.
It's not before it's in Peter.
It is judgment.
Mark.
Which page is the OMR? We were showing the sample OMR. One of the OMR. Which page?
Second. 1131.
Where 1131.
1131.
The sample of OMRs. তার দর্শক দেখছেন
Yes. This is the OMR sheet.
yes
That's a group DA.
Some lot are easily identifiable with the candidate. No one else come and say this is not mine. And the auto division bench gave them opportunity. Come, inspect and tell. None had inspected. The so-called argument of tainted, untainted was never advanced before the division bench. Now kindly take the trouble, come to the division bench, how the division bench dealt with this issue.
Division bench. Page number 2. Not of the volume.
What is it?
Para 3.1. Options available.
Volume China.
Second option was explore the possibility of segregating the valid appointments from illegal ones. Taken up and dealt with. For at page by that with these authorities which are well known. And kindly come to relevant paragraph 321. Process involved. Written examination has been was required to have been preserved by the SSC. CBI had seized the server of SSC and did not find mirror image of sheets in the server of SSC. Skipping over the unnecessary details. Next page, it is unclear whether sorry, is better. SSC is an authority within the meaning of Article for the purpose of scanning and evaluation of sheets. Now, as I evaluating saying also or not. SSC in response to a query of the court has stated that not aware of the engagement of data no material has been disclosed as to who significantly, it is the claim of SSC that scanning of OMR sheets had taken place at its office. If that be so, then SSC had knowingly allowed another organization to scan the OMR sheets, namely Data Scan Tech, who was not authorized at all. This raises serious questions as to the integrity, sanctity, and validity of the entire selection process, and giving to the root of the selection process. The evaluator of the selection process had been selected through a process which at best shrouded in mystery, if not downright illegal. Then the conduct of such evaluator is such that it affects the validity of the process of evaluation itself. Secondly, NISA had been appointed without an open tender. SSC has selected NISA ostensibly on the ground of it being the lowest tenderer from amongst the chosen few who were asked to participate. The parameters, qualifications required to participate remains undisclosed despite requests being made in court to SSC. No explanation has been provided by SSC in course of the hearing as to how and why such a course of action had been undertaken in identifying the instrumentality who was to scan and evaluate OMR sheets. Documents that have been made available on record does not suggest that competency, efficiency, and whether NISA has requisite expertise to undertake such exercise was not considered basis at all. Letter of appointment of NISA contains only 2 lines, which requires NISA to scan and evaluate OMR. No other terms and conditions of the appointment have been specified. The appointment letter has been received by the one employee of NISA from the office of SSC. The next paragraph 326. The entire selection process is shrouded in such mystery and in such layers that it is difficult to fathom the quantum of illegalities performed. That illegalities had vitiated the selection process of NISA stands established. We have discussed the illegalities so far discovered vitiating the selection process in course of our discussions, and we'll tabulate the same hereafter.
325
The possible inference from the materials made on record and the conduct of the relevant parties is that the entire machinery was devised for the purpose of effectuating a scam, which will be hard to discover, and even if discovered, difficult to prove. But for a passing reference, after CBI took up investigation upon raid to the Minister's house, 50 crores cash was recovered. Apart from gold and other property, 50 crore cash. Out of this, as noted above, in the course of hearing all these matters, SSC State Board have perseveringly non-cooperated. Would be rendered regrettable.
So 324.
Finally, সব দেখার দরকার নেই। Blank OMR sheets have been submitted and such candidates have been shown to have scored sufficiently higher number so as to be recommended for appointment and ultimately given an appointment. The exact nature of candidates fraudulently giving the appointments cannot be identified. More so, in view of the attitude of cooperation exhibited by SSC, there are other manipulations have come to light. Again, exact number who have benefited out of such manipulations and illegalities in the selection process cannot be identified in its entirety. Some have been identified. Identification of some of is such that respect of Group D appointments, 48% has been found to be by manipulation. The person across the other three categories are on a reduced scale compared to Group D, but it is significant to question the validity of the entire selection process. Then, without the Honorable Court summarized the legalities at page 335, I'm not reading. But
The report is there.
yes, it is referred to in the judgment.
But it's not. Fine.
Not fine?
In this process,
Before us.
in this process not.
But it is recorded in.
But these are been recorded thoroughly in the judgment.
If you come to page 269, the last report.
Yes.
So there's another issue which is not